The Supreme Court just changed American gun law forever, and most people missed what actually happened. An 8-1 decision rewrote the rules that every gun case will now be judged by. Stay until the end. Subscribe and hit like so this reaches everyone who needs to hear it. The case that reached the Supreme Court. A man named Zachi Rahim got into an argument with his girlfriend during lunch in December 2019. When she tried to leave, he grabbed her, shoved her into his car so hard she hit her head on the dashboard, then fired a gun at a bystander who witnessed it. A Texas court issued a protective order barring him from owning firearms. He signed it, acknowledged it, and completely ignored it. This was not a complicated case of mistaken identity or legal gray area. This was a man who looked at a court order and decided it did not apply to him. Over the next 2 months, he fired a gun in 5 separate incidents and showed up at his ex-girlfriend's house in the middle of the night. When police searched his home, they found 2 guns, ammunition, and a copy of the protective order sitting right there among it all. He was charged under 18 U.S.C. Section 922 G8, a federal law on the books since 1994 that says if a court finds you are a credible physical threat to someone, you cannot possess a gun while that protective order is active. Rahim said that law violated his Second Amendment rights. Here is the one data point that tells you everything about what happened next. After the Supreme Court's 2022 Bruin ruling changed how gun laws get tested, researchers tracked more than 2,000 federal court challenges to gun laws in just 2 years. In the 6 months after Bruin, courts were striking down laws that had been on the books for decades because judges could not find a matching law from the 1700s. The Fifth Circuit ruled that the 30-year-old law protecting domestic violence victims from armed abusers was unconstitutional. In those 3 states, the legal protection keeping a courtified abuser from owning a gun simply disappeared. That is the case that landed on the Supreme Court's desk, and what the court actually did to the entire legal system when it ruled, that part changes far more than just this one case. Breaking down the 8-1 decision. On June 21, 2024, the Supreme Court ruled 8.1 in United States versus Rahim, reversing the Fifth Circuit and upholding the federal law that kept guns away from people under domestic violence protective orders. This was not a close call. It was a near-unanimous message from the highest court in the land that the lower courts had been getting this wrong. Chief Justice John Roberts wrote the majority opinion. Joining him were every conservative, Alito, Gorsuch, Kavanaugh, Barrett, and every liberal, Sato, Mayer, Kagan, Jackson. 8 justices across every ideological line, all agreeing. The one vote against was Justice Clarence Thomas, the same man who wrote the Bruin decision 2 years earlier, the person who created the very legal test that transformed gun law across the country, was the only one who believed that tests should be applied even more strictly. Here is the single data point that puts the timing of this ruling in full context. Legal scholars at the University of Virginia analyzed more than 450 Second Amendment challenges filed after Bruin and found that more than 1 in 3 published appeals. Court decisions concluded the challenged law was unconstitutional. After Bruin, the strike-down rate exploded. Different judges, different circuits, total legal chaos. The Rahim ruling was the Supreme Court stepping in and saying enough. But buried inside Chief Justice Roberts' reasoning is one idea that most people completely overlooked. And that one idea is what actually rewrites the rulebook for every gun case that comes after this one. The majority opinion and its constitutional reasoning. Chief Justice Roberts opened the majority opinion with one line, "Every American should understand." He wrote that the Second Amendment is not a law trapped in amber, meaning the Constitution does not require today's laws to be identical copies of laws from 1791. The founders wrote down principles, not a legal code for every situation that would ever exist. That single line was Roberts telling every federal judge in the country to stop treating the Constitution like a museum piece and start treating it like a living set of principles. Roberts pointed to 2 types of historical laws. Shy laws required people who threatened others to post a financial bond and temporarily lose weapon access. Going armed laws allowed courts to act against people using weapons to cause fear in others. Neither was identical to the modern domestic violence statute, but both showed the same underlying principle that people who pose a credible court-defied threat to someone's physical safety can be temporarily disarmed. Here is the one number most people have never connected to this ruling. The law at the center of Rahim had been protecting domestic violence victims for 30 years without serious constitutional challenge until Bruin created the opening. In those 3 decades, research consistently found that the presence of a gun in a domestic violence situation increases the risk of homicide by 500%. By upholding this law, the court closed a legal gap that had briefly left millions of people without a protection that had existed their entire adult lives. Now, here's what most people are completely sleeping on. The majority ruling does not just fix the domestic violence law question, it rewrites the instruction manual for how every single gun law challenge plays out from this point forward. Do you think the Supreme Court made the right call in Rahim, or did they open a door that will eventually go too far? Drop your answer in the comments below. The lone dissent. Justice Thomas's key points of disagreement. Justice Clarence Thomas's dissent is not a fringe opinion. It is the most strict, most consistent Crown rights legal argument on the entire Supreme Court. And understanding it is essential to understanding what is coming next. While everyone else on the court was ready to move forward, Thomas was the only one willing to stand alone and say the majority had crossed a line. Thomas wrote Bruin in 2022 and built the historical test that changed American gun law. In Rahim, he argued his own test requires a more precise application than the majority gave it. His dissent came down to one statement. The government failed to show any historical law genuinely similar enough to the modern domestic violence statute to justify it under the Second Amendment. Thomas argued that shitty laws were fundamentally different from the modern statute. Shy laws did not take your gun. They required a financial bond while you remained armed. The modern law prohibits possession entirely. Here is the one data point that makes Thomas's concern concrete. After Bruin, gun rights groups filed 34 new lawsuits in the first 6 months alone, and another 34 in 2023. Thomas's argument is that the relevantly similar standard is too loose to protect ordinary gun owners from future restrictions dressed up in historical language. Thomas wrote both Bruin and the Rahim dissent. The 2 most important competing frameworks for Second Amendment law going forward were written by the same man, one as the majority author, one as the only denter. That tension shows up in every major case from here on out, and the next battle is already sitting in federal courts right now, how the ruling reinterprets the Second Amendment. The Second Amendment has been seriously interpreted by the Supreme Court only 3 times in modern American history. Heller in 2008 gave you the individual right to keep a gun at home. Bruin in 2022 extended that right to public carry. And Rahim clarified what the words historical tradition actually mean in practice. Most people know the name of one of these cases, but very few people understand how all 3 connect to form the legal reality you are living in right now. Before Rahim, lower courts were treating Bruin as if it required a nearly identical law from 1791. A federal judge in Mississippi struck down the federal machine gun ban because he could not find a precise 1791 equivalent. Roberts called that out directly. He said, if you apply Bruin that literally, the Second Amendment would only protect muskets and sabers. Here is the one data point that explains why this shift was urgently needed. The Trace built a database of more than 2,000 federal court decisions, citing Bruin in just 2 years. More than a third of published appeals court decisions in that period concluded the challenged gun law was unconstitutional. Laws that existed without serious challenge for decades were being struck down because judges could not find a matching 18th century statute. The new Rahim framework was a direct response to that breakdown. Here is the fact that has not been widely reported. This ruling quietly changed the legal landscape for red flag laws in more than 20 states. Red flag laws were never mentioned once in the Rahim opinion, but the principle protecting them was placed at the very center of it. And the next major Second Amendment confrontation is going to be fought on exactly that ground: immediate impact on federal and state gun laws. The moment the Rahim decision came down, the legal landscape shifted in specific concrete ways, and most of these changes happened quietly, without any major headline. No breaking news alert, no primetime coverage, just a ruling that immediately changed the legal reality for millions of Americans who had no idea the protection they relied on had ever been in danger. The most direct effect was simple. The federal law banning firearm possession by people under domestic violence protective orders was fully restored nationwide, including in Texas, Mississippi, and Louisiana, where the Fifth Circuit had wiped it out. The day the Supreme Court ruled, it came back. Within weeks of the ruling, the DOJ requested the Supreme Court apply the new Rahim framework to 5 other pending Second Amendment cases. The court vacated those lower court rulings and sent them back for reconsideration. That is 5 separate gun restrictions challenged and struck down. Now under review again, here is the one data point that brings the human scale of this ruling into focus. Over 12 million Americans are victims of domestic abuse every single year. Research shows that when a firearm is accessible to an abuser, the risk of intimate partner homicide increases by 500%. Rahim restored a safety net that an estimated 1 in 4 American women will need at some point in their lives. Now, here's what most people are not talking about yet. The biggest downstream battle has almost nothing to do with domestic violence law. It involves more than 26 million Americans with a felony conviction on their record whose gun rights may be permanently stripped. 2 different federal courts have already reached opposite conclusions on this since Rahim came down. It is coming back to Washington, and how it gets decided depends entirely on the framework Rahim just put in place. Do you think red flag laws are a legitimate use of the principle the court created in Rahim, or does it go too far? Tell us your real answer in the comments below. What this means for pending firearms cases. There are cases currently moving through the federal courts that will affect far more gun owners than the Rahim decision ever touched. And unlike Rahim, which most people outside the legal world had never heard of, some of these pending cases involve questions that will directly determine whether tens of millions of Americans can legally own a firearm. The 2 most significant were Range versus Attorney General and Daniels versus United States. Both involved the federal felony in possession ban. In Range, the Third Circuit said that ban was unconstitutional as applied to Brian Range, a Pennsylvania man whose only conviction was a 1995 food stamp fraud case. In Daniels, the Fifth Circuit reached a similar conclusion about a man with old nonviolent drug convictions. After Rahim, the Supreme Court sent both cases back for reconsideration. Both courts applied the new Rahim standard and struck down the bans again. Anyway, 2 respected federal courts reached conclusions that still conflict with the federal government's position, which means this question is coming back to the Supreme Court. Here is the single data point that explains why this is the most consequential unresolved question in American gun law right now. Over 8% of all U.S. adults have at least 1 felony conviction on their record. That equals more than 26 million people currently prohibited from owning a firearm under federal law. If the Supreme Court rules that the felon in possession ban is unconstitutional as applied to non-violent offenders, the number of Americans legally permitted to own a gun would increase by millions overnight. Justice Kavanaugh defended the use of post-ratification history, legal history from after 1791, including the Reconstruction era around 1868. If future courts accept that broader historical window, it opens a much larger pool of evidence that could cut in either direction on assault weapon bans. That debate has not been settled. It is just beginning. Reactions from lawmakers, advocates, and legal experts. When the Rahim ruling dropped, reactions came from every direction. And what is most revealing is not just what people said, but how those responses map on to where the real battles are headed. Pay close attention to how each side framed this decision. because the framing tells you exactly what they are preparing to fight for next. Gun control advocates called it a life-saving decision. Legal policy experts at Johns Hopkins said the ruling reaffirmed that policymakers have the constitutional authority to disarm people who present verifiable threats to others. Organizations focused on domestic violence pointed to decades of research showing that protective order firearm prohibitions reduce intimate partner homicide. The NRA called the ruling narrow and explicitly not an endorsement of red flag laws or any of the dozens of other gun restrictions currently being challenged. That message was aimed directly at gun owners. Do not read this as a setback. This was a limited ruling on a specific fact pattern. Here is the one data point most people never saw. The Harvard Law Review published a formal analysis concluding Rahim was a meaningful course correction, but also noted that the word principle as a standard for Second Amendment analysis does not appear anywhere in the Bruen opinion. Rahim introduced it. That single word changed the constitutional test in a way that will affect every gun case for decades. Even the liberal justices who dissented in Bruen, Sotomayor, and Kagan joined the Rahim majority, not because they changed their view that Bruen was wrongly decided, but because Roberts' interpretation of Bruen is significantly less dangerous than Thomas. That calculation alone tells you everything about how high the stakes are in the cases that are coming. The long-term implications for the future of gun rights. Rahim is not the end of anything. It is the opening chapter of a long process where the Supreme Court is building one case at a time, a complete constitutional doctrine for the Second Amendment that will shape American gun rights for the next generation. Most people will not realize how significant these decisions are until they are already living with the consequences, and by then, the framework will already be locked in place. The three foundational rulings are now in place. Heller gave you the individual right to own a gun for self-defense at home. Bruen extended that right to public carry. Rahim defined what historical tradition means in practice. Not a precise copy from 1791, but a principle the founding generation recognized and applied. Here is the one data point that frames the full scope of what is at stake. The Trace compiled a database of more than 2,000 federal court challenges to gun laws filed after Bruen in just 2 years, an unprecedented volume of Second Amendment litigation in American history. Rahim settled one piece of that legal storm, but challenges to felon bans covering 26 million people, assault weapon bans in the 3 largest states, carry restrictions in dozens of cities, and red flag laws in 21 states are all still moving through the courts right now, waiting for the next Supreme Court ruling to land. The real divide on this court is between those who want the Bruen test applied as a strict rule-based system and those who want the ability to interpret founding-era principles in light of modern circumstances. Thomas is firmly in the first group. Roberts, Kavanaugh, and Barrett are clearly in the second. The question is no longer whether the Supreme Court will shape the future of your Second Amendment rights. It already is. The question is which direction the next major ruling, whether 8-1 or 5-4, takes us. What do you think the Supreme Court should take up next on the Second Amendment, the felon ban, assault weapon bans, or red flag laws? Tell us exactly which case you want to see covered and why, and drop it in the comments right now. That is the full picture of what this 8-1 decision really means for your Second Amendment rights, and the biggest battles are still coming. If this video helped you understand what is at stake, subscribe right now, hit the like button, and drop your thoughts in the comments because your voice in this conversation matters more than you know.